after being arraigned from other inmates. And so at this time, given that he violated his bond, I'm going to be asking for him to be remanded and that his phone privileges while in custody be revoked.
Mr. Allen, please.
And Your Honor, Ms. Zenda relayed that information to me this morning, and I believe the people are working to get the phone calls over to us. I haven't had the benefit of reviewing those for their subject matter or the times those calls were placed. However, Mr. Buford admits to contacting the complainant while he was in custody.
Post arraignment.
I can't corroborate that at this point, Your Honor, and I'd ask to come back on the 16th when I've had the ability to do that. What I would ask the court to consider, Your Honor, is that Mr. Buford's 27 years old. I don't believe he has any criminal history, and see that he has 2 open pending traffic matters, but certainly nothing assaultive or felonious. Mr. Buford is employed full-time, and he has stable housing apart from the complainant. Part of the bond that was set in this case involved a hot zone tether, and I think subsequent to his release, I don't believe there have been any additional allegations of misconduct while on bond. So I'd ask the court to consider continuing his bond at this time pending a hearing on the 16th, Your Honor, or a probable cause conference on the 16th.
My understanding is you have them post arraignment.
Correct, Your Honor. I believe they're exclusively post arraignment. He was arraigned on the 27th, and the calls begin, the completed calls from other pins begin on the 28th and go into the 29th.
And these aren't 1 minute calls, as I understand. There's
14 minutes, 25 seconds, 15 minutes, 14 minutes, 36 seconds, 15 minutes, 15 minutes. Full duration of the calls that you get while in custody is 15 minutes.
Your Honor, I have absolutely no reason to doubt that. I just want to make sure that I'm complying with my duties to corroborate that information.
I understand. What I will do is probable cause conference will be adjourned to the 16th, 2026, 9 a.m. Defendant, he's not really admitting to the violations because you don't have the timing other than what the people have indicated, but they given the court enough. Defendant's bond at this time is revoked. Defendant's remanded. I'm also revoking phone privilege. He has that includes texting.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Matthew McLean.
That is on behalf of the people, Your Honor.
Anybody make a decision?
Yes.
Thank you.
Stephanie Canna on behalf of Mr. McLean. Please state your name for the record.
Matthew McLean.
If you must, yes. All right, record should reflect we've had a bench conference in this case. Go ahead.
This is a major turning point in the hearing. The judge isn't punishing the defendant simply for making phone calls. It's the fact that those calls allegedly happened after arraignment, while strict bond conditions were already in place. Once a court orders no contact, even indirect communication can be treated as a serious violation. The length and frequency of the calls also appeared to have influenced the court's decision. Even though the defense requested more time to review the evidence, the judge determined there was enough information to act immediately to protect the integrity of the case. What do you think? Should the court revoke someone's bond based on this preliminary evidence, or should it always wait until every recording has been fully reviewed? Let us know your thoughts in the comments.
It's fine. It's come to my attention that Mr. McLean has not been directly contacting the victim, but I have come by a few jail calls that concern me, in which he's telling his family members, tell her that he loves her, as well as also mentioning to those specific family members who he's trying to get to be in contact with the victim, that if she does not show up, that the case would be dismissed, and suggesting things of that nature to them as well. So I have concerns, given that at first it's just to reach out with my love yous, but then it's also suggesting outcomes that could interfere with this criminal case. So at this time, I'm going to be asking that the defendant be remanded, and that text privileges in the jail where you want to give it.
And Your Honor, in response to that, there's been no evidence presented whatsoever that any information has been communicated to the complaining witness in this case. And just because he has knowledge of how things typically go in this matter and has expressed that knowledge is not indication that he has been trying to tamper with the case or the witness in any way, shape, or form. He's not in communication with her now. He's very concerned about her right now. I told the court, and that's because there's been no communication whatsoever. She has been on repeat calling his family, and there'll be evidence of that if we do proceed further. Trying to see what she can do to get the case dismissed. And that's evidence that we are going to be presenting to the court, and her taking culpability for the incident as it happened. I understand the prosecutor's position. And my client since then has not made any communication, reached out any way, shape, or form. Matter of fact, when he came in, because she has stopped communicating with her family and his family, he wanted to know if it was okay to call to get a welfare check on her because he knows her mental health status and her drinking status. Your Honor, my client has, as soon as he got out, he went and checked himself. He went into the Don Farms outpatient program.
And I'm accepted for inpatient.
Into their inpatient program because he understands that a part of this incident stems from both of them and their sobriety and challenges with sobriety. So as soon as he got out, he came in and told me this is what he was doing, and I told him that's really good.
I have an official letter.
And so he is trying to fix this and straighten it out. He is aware that he cannot communicate with her directly or indirectly, Your Honor, and he will not be doing so.
Yeah, but they're repeated indirect calls. As I indicated to counsel, the concern sometimes when you get the I love yous, that can be concern. When you get wanting to check on somebody, can be a concern. I don't know that from the court's perspective that is such a concern, but when you start talking about how the case to these same third parties about that, basically if she doesn't show, then the case gets dismissed. And you're telling them in essence to communicate certain things to this person, that becomes a problem. And he shouldn't have been doing it in this case, or certainly have made it clear he shouldn't have been communicating to third parties about her anyway. Some of it might be able to be excused, but I can't excuse that. So what I'm going to do is I'm going to adjourn the probable cause conference to.
Oh, Your Honor, we were asking for the exam to be set.
Okay, then it won't be addressed till the 21st, if that's what you want me to do. Otherwise, I'd give you a week, the 16th, your choice.
The 16th, Your Honor. We'll take the 16th, Your Honor.
I'll adjourn probable cause conference to July 16th, 2026, 9 a.m. At this point, given what the court has heard before.
The second case reinforces an important legal principle. Courts don't only examine direct contact with an alleged victim, they also pay close attention to indirect communication through friends or family members. Even messages that seem caring or discussions about what could happen if someone doesn't appear in court may be viewed as attempts to influence a witness or interfere with the judicial process. In both hearings, the judges placed protecting the legal process above the defendant's requests to remain free on bond, ultimately revoking their release privileges. These decisions highlight how seriously courts treat any conduct that could undermine a criminal case while it's still pending. Do you agree with these rulings, or do you think the judges were too strict? Share your opinion below, and if you enjoy real courtroom breakdowns with clear legal analysis, don't forget to like this video, subscribe to the channel, and turn on notifications so you never miss our next courtroom case.
Defendant's bond is ordered revoked, defendant's remanded.
This is in this one.